Hello and welcome to Compliance Briefs on Sanctions. In this presentation, we cover a comprehensive overview of sanctions, beginning with what sanctions are and who can issue them. We then delve into the types of sanctions. The video also outlines basic sanctions terminology by considering the difference between a derogation and an exemption. We discuss the concept of ownership and control related to list-based sanctions that determine whether a legal person should also be considered under sanctions. We continue to explore the concept of sectoral sanctions and the importance of safeguarding against circumvention attempts. Finally, we review the penalties associated with breaches of the sanctions provisions. What do we mean by sanctions? Sanctions are a foreign policy tool used to prevent conflict or respond to emerging or current issues without resorting to military action. They are non-punitive measures in nature, usually in the form of prohibitions and restrictions. Sanctions include a variety of measures including asset freezes, arms embargoes, trade embargoes, travel bans, suspension from international organizations. They can target entire states, individuals and legal persons, organizations, vessels and aircrafts, etc. Sanctions are issued by the United Nations, the European Union as well as individual states. Cyprus' legal framework consists of both primary and secondary legislation. The implementation of the provisions of the resolutions or decisions of the United Nations Security Council, sanctions, and the decisions and regulations of the Council of the European Union, restrictive measures, law of 2016 gives direct and immediate effect to all sanctions and restrictive measures adopted by either the UN or the EU to the Republic of Cyprus. The Combating of Terrorism and Protection of Victims Law of 2019 sets the framework specifically for terrorism-related sanctions. The Import and Export of Controlled Items and the Conducting of Controlled Activities Law of 2011 provides the legal framework for import, export restrictions and controls and the granting of relevant licenses. All the above legislations are directly applicable upon any person in the Republic of Cyprus, and breaching any of their provisions amounts to a criminal offence. ICPAC, as a supervisory authority, has issued its sanctions directive, which is binding upon all its supervised members. The directive sets out obligations for the implementation of an effective sanctions compliance program. There are four main categories of sanctions, mainly comprehensive sanctions that target entire countries or geographic regions, prohibiting most activity with those targeted. Regime-based sanctions that target current or former governments or regimes. Sectoral sanctions that target key sectors of a country's economy, and list-based sanctions that target persons involved in defined types of malicious activity. In practice, most sanctions regimes imposed usually involve a combination of the above categories of sanctions. As such, ICPAC-regulated persons should be aware of all sanctions regimes applicable to their business relationship. This means that, even if a client is not named as a designated person in the sanctions lists, its activities or jurisdictions of operation may still be affected by other sanctions prohibitions. It is very common for sanctions regulations to contain provisions for derogations and exemptions. A derogation refers to a deviation from the prohibitions in order to fulfill a specific need. Derogations are only granted for specific reasons, such as to satisfy the basic needs of designated persons and their dependent family members, including, for example, payments for food, rent, mortgage, medical treatment, legal expenses. Also, they may be granted for providing humanitarian aid, for implementing certain types of arbitral, judicial or administrative decisions, and for payments due under a contract or agreement concluded before designation date. Derogations are always subject to prior authorization by the competent authority, and only after obtaining such an authorization may a release of frozen funds or a provision of service take place. An exemption refers to situations that remain outside the scope of the prohibitions and as such do not require prior authorizations. Exemptions are specifically mentioned within the sanctions provisions. Regardless of an authorization, servicing clients subject to sanctions bears an increased reputational risk that obliged entities should seriously take into consideration. Now, we will explore the notion of list-based sanctions. What do we mean by designated persons? Designated persons are natural and legal persons against whom asset freezing measures are imposed. This in practice means that their assets and economic resources must be frozen, and there is a general prohibition of not making any funds or economic resources available to them. the prohibitions do not apply only to the designated persons but also extend to entities owned or controlled by them as well as to their family members and non-designated third parties. What we mean by owned or controlled. The ownership criterion is satisfied when the designated person owns, directly or indirectly, 50% or more of the entity. The rule applies in the aggregate as well. If, for example, a company is owned by more than one designated persons, their percentage will be added, and if it adds up to 50% or more, then the company comes under the sanctions prohibitions as well, as it is illustrated in the examples included in this slide. Sanctions against designated persons could also extend to family members or non-designated third persons if defined criteria are met. Further guidance on the ownership and control criteria can be found in ICPAC's guidance on sanctions and restrictive measures available on ICPAC's website. You should bear in mind that, if the ownership criterion, as already described, is not met, then an entity could still come under the sanctions prohibitions if specific criteria for assessing control by a designated person are met. A number of factors exist to assess the control criterion, including, but not limited to, having the power to appoint or remove the majority of the management members of the entity, controlling the majority of the voting rights, and having a dominant influence over the entity. If, following an assessment, it is believed that the entity is controlled by the designated person, then the asset freezing prohibitions apply to the entity as well. Sectoral sanctions refer to economic and financial measures in the form of import and export restrictions, bans on services, restrictions on banking, arms embargoes, and import and export restrictions of dual-use goods and items listed in the Common High Priority List. Similarly to the asset freezing prohibitions, sectoral sanctions also provide for derogations and exemptions. However, unlike asset freezes, sectoral sanctions vary by article. Some may allow specific exemptions, while others may not provide any at all. As a result, they must be assessed on an article-by-article basis. If a derogation is provided, then an authorization must be obtained prior to the provision of the service or the trading activity. You should keep in mind that, if an authorization is provided, it is based on specific terms and conditions and applies only to a particular client for a specified service within a specified timeframe. It cannot be used for any other client or service for which you assume that similar characteristics apply. The term sanctions circumvention refers to the knowing and intentional participation in activities the object of which is to circumvent the sanctions prohibitions. This means that the person is at least aware that his/her actions may result in the circumvention of the prohibitions and accepts it. There are various red flags that may indicate circumvention attempts, and as such you should remain vigilant and alerted to methods employed and new tactics used to circumvent the sanctions prohibitions. You should remember that the best method to safeguard against sanctions circumvention is to have a concrete sanctions compliance program. This includes solid customer due diligence procedures that will enable you to effectively identify, mitigate, and monitor any sanctions and sanctions circumvention risks, rigid customer due diligence procedures that will allow the detection of clients' counterparties that may be subject to sanctions restrictions, have activities that may be captured under the prohibitions or present characteristics that could result in a higher risk level of the business relationship. Also, application of enhanced due diligence procedures for the specific high-risk elements is crucial. At this point, we will explore the implications of not complying with the sanctions provisions, including provisions on circumvention of sanctions. Breaching a sanctions regime is a criminal offense. For physical persons, it carries an imprisonment sentence of up to 2 years or a financial penalty of up to €100,000 or both. For legal persons, it carries a financial penalty of up to €300,000. Apart from the criminal penalties, breaching a sanctions provision would most probably result in the imposition of an administrative penalty as well, both financial and non-financial penalties, for failure of your firm's sanctions compliance program. In all cases, and irrespective of the imposition of a penalty, you should always consider the reputational damage caused if you are in any way associated with sanctions breaches. Finally, ICPAC has issued a number of guidance, in an effort to enhance awareness and facilitate its members to navigate the complex legal and regulatory framework relating to sanctions. The guidance can be located on ICPAC's website, under the tab Monitoring and Compliance, in the Compliance Guide section. I hope you found this useful. For any queries you may contact us at compliance@icpac.org.cy. Thank you and goodbye.